G'day, it's fugitive Australian journalist Shane Dowling from the website kangaroocourtofaustralia.com. Now, in a minute, you're going to see Commander Michael Chew from the Australian Federal Police ducking and weaving, giving every excuse possible, including blaming COVID, for the police sending Brittany Higgins' personal counselling notes to Bruce Lehrmann's lawyers before the trial, the rape trial. Now, the recording is from last Friday, the 26th of May, 2023. And he's initially being questioned by Aaron Longbottom, who's counsel assisting the ACT inquiry into police corruption. And then he's questioned by Shane Drumgold's barrister, Mark Tedeschi. At the end there, Mark Tedeschi questions him for the last 5 minutes and absolutely nails him. Now, there's a whole heap of reasons why Brittany Higgins' notes, counselling notes, shouldn't have been sent to Bruce Lehrmann's lawyers. Firstly, there's meant to be a process that's followed, which filters out any confidential information. The police decide to charge a person, and then they issue a summons, and then the brief of evidence goes to a sergeant, the senior sergeant, who checks all the documents, make sure they're all okay. Then it goes to another sergeant, then it goes to the legal team, and then it's sent to the Director of Public Prosecutions, who's meant to serve the brief of evidence on the alleged criminal. But in this case, it didn't happen, and you're about to see that play out where Aaron Longbottom is questioning Michael Chew and Commander Michael Chew, and he's ducking and weaving, and he blames anything and everything. So the video goes for 18 minutes and is well worth watching. You're going to see a commander of the Australian Federal Police duck and weave for 18 minutes, and right at the end, the last 5 minutes, Mark Tedeschi absolutely nails him. And I'll have a lot more to say on these issues in the near future, so if you're not a subscriber, make sure you hit the subscription button and the notification button, and we'll listen to the video now.
Am I right to understand, Commander Chew, that you were responsible for issuing the direction that the brief be served directly on defence together with the summons?
Yes, I was.
Can you talk me through what the ordinary process is for adjudication of a hearing brief?
The normal process is the case officer compiles the brief of evidence, which goes to their sergeant or team leader for a review of the evidence presented and all the evidence collected. That then goes to an adjudication position or sergeant, who looks at it again from an evidentiary perspective and to ensure that all the statements and everything are there.
Can I just stop you there? And I just want to bring up a document, AFP.001.0001.0706. Am I right that the adjudication process that you've just referred to is documented?
Yes, it is.
Okay. Is this the document or the form that is intended to record that adjudication process?
It appears to be, yes.
Yes. Okay. Please go on.
After the team leader makes an assessment, and you'll see in that form there's various sections of it that relate to the informant and then the sergeant. After it's adjudicated on, again, to check the sufficiency of evidence and the statements, et cetera, then it goes to judicial operations to essentially be checked for content and administrative purposes to make sure it's in line with the agreement or the protocol document between ACT, DPP and ACT Policing.
So just stop you there. Judicial operations, that is a body within ACT Police?
Yes, it is.
And you refer to it checking content. Is an aspect of that to ensure that material is not included in the brief that is either the subject of a privilege, such as legal professional privilege?
That should be in disclosure statements.
So that's the fact of that is recorded in the disclosure statements?
I think so, yes.
But is your understanding that it is a function of judicial operations to ensure that such information is not actually included in the brief of evidence?
Yes.
Now, another aspect of documents that might be included in the disclosure statement is a material that's subject to statutory protection, such as counselling records.
Yes.
And am I right to understand that an aspect of the function of judicial operations within ACT Police is to identify and ensure that material matching that description is not included in the brief of evidence?
Yes.
Okay. So what happens from there?
Then that document or that brief is sent across to the ACT DPP for allocation to a prosecutor, and then the prosecution commences.
And am I right to understand that there is a collaborative agreement between ACT Police and DPP?
Yes.
And an aspect of that collaborative agreement provides for a brief of evidence to be provided to the DPP within a particular period after a summons is laid?
Yes.
Is your understanding that an aspect of the function of the DPP with respect to the brief of evidence is in effect to be another check and balance regarding the content of the brief and to ensure that material that is subject to statutory protection or legal professional privilege is not included in the brief that's served on defence?
Yes.
Now, if we can go to the 3rd of August, on that day you had a meeting with Detective Superintendent Moller. Now, again, you don't have a file note of this meeting, but I want to suggest to you and give you an opportunity to comment upon what Detective Superintendent Moller records of that conversation. He records that you said that there is no need for adjudication. We have had it independently reviewed and have legal advice, so no need to have it adjudicated. Is that a correct?
Well, no need to have it adjudicated through the normal process.
And when you say adjudicated, what do you mean by that?
Well, due to the nature of the investigation and the fact that it had a lot more oversight from various levels of detective sergeant, detective inspector and detective superintendent, the adjudication on the sufficiency of the brief to go forward had been done at those stages.
So when you say sufficiency of the brief to go forward, are you talking about sufficiency of the evidence included in the brief, or are you talking about an adjudication process to ensure that only the proper content that can go to the defence is included in the brief?
The latter.
The latter. Can we just go back, though, to the direction you actually issued with respect to at least the DPP? Operator, can you please display AFP.2003.0002.8605 and turn to .8606. Would you accept, Commander Chew, that no part of your direction in relation to what was to occur, what was to be done by the ACT DPP included an adjudication of the content of the brief of evidence in terms of whether or not it included statutory protected material or material concerning legal professional privilege and the like?
Yes, I accept that.
Okay. So would you accept, albeit with the benefit of hindsight, that when you said to Detective Superintendent Moller on the 3rd of August, the brief has already been adjudicated, at least insofar as it concerned the DPP, it hadn't been adjudicated for its content?
That would be acceptable, yes.
Okay. Now, 2 days later, on the 5th of August, you have another meeting with Detective Moller. Again, you don't have a file note, but I'll put to you what Detective Superintendent Moller records of that conversation. There was a discussion in relation to service of the summons on Mr. Lehrmann. Do you recollect that?
Yes.
During the course of that discussion, Detective Superintendent Moller said to you, and this is with respect to service of the brief, I suggest, this is outside our normal procedures. Normally we go through the AP Sergeant for adjudication. I think we should still do this ?
Yes.
Yes?
I recall a conversation like that, yes.
And you said to Detective Superintendent Moller, we can't, mate. We can't, mate, no need. We have had it reviewed and I'm comfortable with that. let's just get it served and move on?
That would be a reflection of that conversation, yes.
What was operating on your mind in terms of that statement that you just wanted the matter to move on without an adjudication in the face of Detective Superintendent Moller expressing concerns to you about that ordinary process not happening?
My concerns or my thinking at the time was that the matter had dragged on. We had the director's advice that the matter should go to court or should commence a prosecution. We had the intense media scrutiny in the environment that was occurring at the time. The brief or the brief of evidence had been compiled throughout the investigation, and the fact that we were operating in a COVID restrictive environment, which made a few normal practices quite challenging in relation to service of summons, adjudication of brief. And additionally, due to the commentary that was being held, the possibilities of fair trial for the alleged offender, with all the media commentary and the commentary surrounding it, would be challenging.
Can I just unpack that with you? You say that, I think in effect, it had been looked at by various senior investigating officers, but you accept that it hadn't been adjudicated by those officers in terms of its content.
Yes.
And you were directly informed by Detective Superintendent Moller that that was a matter of concern for him.
Yes.
In terms of the COVID environment, what was it about the COVID environment that precluded an adjudication process happening?
Well, the courts were operating on restrictive operating hours. As I said, my intention was that the amount of oversight and adjudication progressing through the investigation was sufficient to provide the brief of evidence in relation to the sufficiency of the evidence.
But how could you have been satisfied in the face of what Detective Superintendent Moller said to you, that there was a sufficient adjudication of its contents in terms of the production of material that shouldn't be included in the brief?
I accepted that during the process of, as I wasn't directly involved in the compilation and the compiling of the brief, and I would have expected that those checks and balances would have been occurring along the way.
You probably assumed that this brief had been passing through many hands, including the directors, and by that stage, surely everything that should have been taken out had been taken out.
That would be correct, yes.
You referred earlier to a concern about the matter dragging out. Was an aspect of what was playing on your mind in terms of issuing that direction adverse comment about the DPP with respect to dragging its feet to lay a charge?
No, I wouldn't say that. No.
Coming back to the question about the COVID environment, you talked about how COVID could operate in terms of the court processes, but I'm just struggling to understand how COVID would have precluded an adjudication happening either internally within the ACT Police, as Detective Superintendent Moller was urging you to do, or otherwise having that done by the DPP.
It wouldn't have precluded it, but as I said, the matter was dragging on and the commentary surrounding the matter was increasing.
So would it be fair to say that those two matters you've just mentioned, the matter dragging on and the media commentary increasing, was really what motivated you to issue the direction on that day?
Yes.
And would you accept that in hindsight, albeit that really shouldn't have occurred?
Yes, in hindsight, yes.
Yeah, and that's because a proper adjudication process hadn't taken place?
Yes.
Nothing further from me, Mr. Sock.
Thank you. Mr. Tedeschi, for various reasons, we have to adjourn at 4 today. So you can start, or you're not going to finish in 20 minutes.
I might. I might.
All right.
I'm content to start.
All right, go ahead.
Commander, would it be fair to say that you and the other police involved in this case were under a lot of time pressure that led to your decision that there be no adjudication in this matter?
Yes.
There was pressure from the media, pressure from Ms Higgins and her partner, and pressure from other sources as well, including pressure from the DPP.
Yes.
Do you agree that it's very unusual not to have an adjudication of a brief that goes out?
Yes, it is.
It is common?
It is unusual.
It is unusual. And is it also very unusual for the brief to be served at the same time as the summons?
Yes, it is.
Usually what happens, is it not, that the police wait until they find out if there's a plea of not guilty and then they put the brief together and serve it?
Generally, yes.
That saves a lot of time, because if there's a plea of guilty, you don't have to go to the same amount of effort to prepare the brief.
That's correct.
So this case was very unusual from the point of view of the parties, that the brief was served at the same time as the summons. In order to save time, why didn't you just have the summons served as quickly as possible? Why did you decide to have the brief served as well?
Again, to start the progression of the matter, so that to expedite the potential of getting the matter before court at its first mention date, which would then allow us to seek suppression orders from the magistrate to limit, if not reduce, the external commentary that was occurring.
But you could have got that just with the summons being served without serving the brief at the same time?
In hindsight, yes.
And of course, the other thing that was very unusual was that the brief was served directly by the police on the defence rather than through the DPP.
Yes.
I think it's the agreement between the police and the DPP is that the police provide the brief to the DPP, who then serve it on the defence.
Yes, that's correct.
As you've explained to counsel assisting, that provides another level of checking.
Yes, it does.
So from the point of view of the parties, this was also very unusual, would you agree, in terms of the service of the brief directly on the defence?
Yes, it was.
Now, you subsequently found out that accidentally some counselling notes of Ms Higgins were included with the brief?
Yes, Detective Superintendent Moller informed me of that, yes.
That should not have happened?
Should not have happened.
And is this the only occasion that you're aware of where that's happened?
It's the only occasion that I'm aware of, yes.
All right. And were you also informed that the audio of the complainant's EICI was also served with the brief and that shouldn't have happened?
I can't recall if I was informed that the EICI had been served, but definitely the counselling notes.
Yeah. Did you find out, or do you know now, that the audio or video of Ms Higgins's interview had been included with the brief and it shouldn't have been?
Yes, I know now.
Okay. And did you also find out that there were some redactions of personal details of police officers and witnesses and the like that hadn't been applied properly, and that they could easily be lifted so that people could see what was under the redactions?
Now I do, yes.
Right. Now, would you agree with this, that in terms of this matter resulting in the brief being served at the same time as the summons, the brief being served on the defence directly, the counselling notes being included with the brief, the audio of Ms Higgins's interview being included with the brief, and the redactions being able to be lifted, that the combination of all of those events was completely unique to this case?
Yes.
You were the one who took responsibility for saying charges should be laid?
Yes, I was.
And Superintendent Moller was the one who actually signed the summons?
Yes, he was.
And you would have heard Erin Longbottom, when she was questioning Michael Chew, saying, struggling to understand what COVID's got to do with it. Well, it had nothing to do with it. He was just making up a lie. He just started making up lies and he got busted in Kangaroo Court of Australia's independent media. I publish a website, YouTube channel, Facebook page and Twitter account, and I'm reliant on donations to keep on publishing. So please support my Patreon account. It's currently sitting on 245 supporters donating $1,412 a month. And you can donate any amount, $3, $5, $10, $15, $20, $30, whatever suits your budget. And I really need to get to at least 500 patrons to be viable. So please support that. And please share this video on Facebook and Twitter, etc. Thank you for your time and have a good day.